நான் வந்து ஜாயின் பண்ணிக்கிறேன்னாரு.
இல்ல சார் வந்துட்டாரு, சார் வந்துட்டாரு சார்.
ஓகே ஓகே ஓகே,
ஒரே நிமிஷம் சார், ஒரே செகண்ட். இல்ல சார் நான் உள்ள அலோவ் பண்ணல, நான் ஹோஸ்ட் இல்ல. மேடம் மேடம் யூடியூப்ல ஸ்டார்ட் பண்ணியாச்சுங்களா மேடம்?
Hello, Mr. Kannan, live aayirukku. You can just take over. I'm just changing the host permission to you.
Okay madam, thank you madam, thank you madam.
Yeah.
Sir start பண்ணீங்களா சார்? செந்தில்ராஜா சார் ஸ்டார்ட் பண்ணீங்களா சார்? செந்தில்ராஜா சார் ஸ்டார்ட் பண்ணிடலாம் சார்.
ஹலோ
சார், ஹலோ சார்.
ஸ்டார்ட் பண்ணிடலாங்களா?
ஸ்டார்ட் பண்ணிடலாம் சார்.
ஓகே ரைட். Very good morning to all. Success is not the key to happiness. Happiness is the key to success. If you love what you are doing, you will be a successful person in this world. Very warm good morning to everyone present here. I take this opportunity and privilege to warmly welcome all our delegates for this 46th webinar series on Introduction to Intellectual Property Patents. This program is a part of 59th National Pharmacy Week celebrations in our country. In this junction, it's my gratitude and privilege to welcome our Chairperson Madam and Director, JKK Nadaraja Education Institutions for their valuable support. Next, it's my great pleasure to welcome beloved Principal Dr. R. Sampat Kumar for this webinar. He is the backbone and mentor for us to reach this much webinar series at our JKK Nadaraja College of Pharmacy. I welcome you, sir. Next, it's my grateful to welcome Vice Principal Dr. R. Sanmasundaram for his valuable support for this wonderful session. I welcome you, sir. Next, I would like to take this opportunity to express my deep appreciation and honor to welcome today's chief guest and speaker, Mr. Ajit Rahul, patent consultant, intellectual property patents, Intellect Dossier LLP, Mumbai. I welcome you, sir, for this wonderful session.
Thank you.
Next, it's time to welcome our delegates. I express my deep appreciation and welcome all the HODs of the department and all the faculty members of JKK Nadaraja College of Pharmacy for this 46th webinar series. I welcome you, sir and madams. It's my time to welcome all the delegates. Yes, I am happy to grateful to welcome all the students of JKK Nadaraja College of Pharmacy for this 46th webinar series. I hope that we all will get enriched from this patent webinar in this session. Next, it's my pleasure to welcome all the distinguished faculty members and teachers from other institutions across the state and country for this 46th webinar series. I welcome you, sir and madams. I am happy and grateful to welcome all the student delegates from other institutions across the state and country. Last but not least, I strongly hope that all of the delegates and guests gathered here will enrich our knowledge about intellectual property and patents after completion of this webinar series. Once again, I am most grateful and thankful to all for your wonderful and active participation and support. I hope that you will have a great time ahead. Thank you one and all. Now, I call upon Dr. Cindy Jose, Assistant Professor, Department of Pharmacy Practice, to introduce our today's resource person, Mr. Ajit Rahul. Please, ma'am.
Good morning, all. Let me begin by thanking the Department of Pharmaceutical Chemistry for this opportunity to introduce Mr. Ajit B. Raul, Patent Consultant, Intellect Dossier LLP. Mr. Raul has worked in leading law firms and technology corporations. He has more than 19 years of diverse experience in IPR and technology. His practice areas include patent portfolio management, patent opinions and strategic counseling, patent prosecution, patent due diligence, designs, semiconductor design layout registration, transactions, mergers and acquisitions, transactions licensing, transactions technology transfer, transactions IP valuations. He has represented numerous Indian and international clients, premier science institutions, and universities. Mr. Raul holds a master degree in electronic communication. He also holds postgraduate diploma in VLSI design and an advanced diploma ADCSSA and A for software design and analysis. He is an alumnus of IIM Calcutta and holds EPBM. He has also undertaken the Executive Management Program for Ethical Management at MRA Institute of Management. Mr. Raul is now registered to practice before the Indian Patent Offices. With this brief introduction, I welcome Mr. Raul to take over the session on Introduction to Intellectual Property Rights. Please, sir.
Good morning, everybody. First of all, I thank you, Dr. Sundaraja, and team to give me this privilege to hold this session on introduction to intellectual property patents. This session is outlined to cover basically what is intellectual property, what is the need for intellectual property rights, the types of intellectual property rights, then what is the invention, what cannot be patented in India, the types of patent applications that can be filed in India, and at the end, I would like to cover some of the common questions those are always arise in mind of inventors and applicants, and a just brief guideline on how to work with your patent attorneys. Intellectual property rights. This statute defined intellectual property right as a statutory right once granted allows the creator or owner of the intellectual property to prevent others from exploiting the same commercially for a given period of time. This is basically a right that is a statutory right that is governed by the statute and managed by the legislative provisions. So, and it is granted for a period, limited period, to the creator or owners of the intellectual property. But this is a right which is granted to prevent others from exploiting the intellectual property. And it's not the right granted for the practice of the intellectual property, but it is a sort of a negative right that has been granted by the statute. Now, this particular intellectual property right is granted for intellectual property. So what is basically intellectual property? Intellectual property is a property created as a result of intellectual and creative efforts or commercial reputation and goodwill. The intellectual or creative efforts, those are the efforts maybe amounted for creation of a picture or creation of a design or even for technical invention. And when we talk about commercial reputation, it is basically establishment which generates a reputation in the market while performing business and establish a goodwill. So basically, intellectual property is again have a human intervention creation. Why now? Why this intellectual property is so important? Why everybody should bother about it, and why we should look at it? See, basically, whether you are on side where you are on side where you are a creator or you want to protect your own ideas, you should you should have understanding of the IPR or your right. At the same time, to protect your ideas and to let others know what are your creations and what are your properties. The way we have fences for the physical properties, intellectual property are defining the fences of your own property. So basically, to protect your own ideas, when you are a creator of the idea or you are owner of the idea, you need to understand and own the intellectual property right and let others know your boundaries. On other side of the wall, if if you want to explore somebody's idea, if you want to modify or if you want to work upon somebody's idea, then you should have understanding of the intellectual property right of that person so that you don't become a trespasser. You don't infringe somebody's right. You don't really, encroach somebody's territory. So what are the basic things what IP can really prove useful for you? IP makes your business distinguishable and sets it apart from competitors. Basically, when you have intellectual property, definitely you have a edge over your competitors. Okay, IP helps you to obtain revenue by selling it or in the form of royalties by licensing or franchising their IPs. The trademarks, logos, business names carry the goodwill of the company with them. Patents and design. These are the IPs which actually directly encompass and affect the production and distribution of your goods. Basically, the patent can be converted or even derived to a product or multiple products. So similarly, the design, so it defines the boundary of your products, it defines the market capture, the share that you can, take into a market. The aspect of businesses which can be protected include the business names, logos, trademarks, designs, inventions, confidential information, trade secrets, or other creative works that differentiate your business. The emerging importance of IPR. What are the importance? Now, when we are going for intellectual property, first we should understand what is the importance. Once we realize the importance, definitely we will strive for it. So an IPR, again, as I said, it is a negative right. So it is a license to sue somebody who is encroaching your boundaries, who is, infringing your product. So basically, you can have and protect your competitive advantage. That is, you can keep aside the competitors in the market. IPR becomes a negotiation tool when you are dealing in market at the same time when you are dealing with your customers. Basically, the IPR, intellectual property right that you hold, also is a marketing or PR value tool where it gives you a unique presence in the market because when you hold an IP, it is the uniqueness that is defined in the market. IPR help you to build relationships. Likewise, when you have IP, say for example, if you have patents, you can share it in patent pooling, wherein your patent right will be used or your patent will be used by other product developer, as at the same time the technological development and patents held by that particular company is available to you. So this can help you in building partnerships. Yes, the IPR gives access to attract capital, in the sense when you have an IPR based product, basically that is the assurance of ownership of that product and certain market share. So definitely IPR acts as a very good tool to attract capital in market. IPR, again, it's a wealth creation. The more of the IP you have, the value of the organization increases and the valuation goes high. IPR gives you a legitimate ownership of your design, of your product, or of your creative art. Basically, IPR gives a monopolistic market advantage, because unless and until somebody don't take a legal permission from you, and that person cannot practice the invention or cannot come up with a competitive product or cannot copy the product and enter into the market. Intellectual property right again gives a establishment, a face of a trustworthy organization, because when you have an IPR, that is where you establish that you are a legitimate owner and you have a foot base and a strong foothold in the market for given product. And yes, most importantly, the IPR allows you to stay in business and keep others out. So these are the few important of IPR with which we'll proceed to understand what is the intellectual property right. Now, the origin of intellectual property rights lies in a statement or in a say that what is worth copying is prima facie worth protecting. Now, obviously, people will try to copy things which have a certain value. Okay, and definitely we need to protect our own creations or our own wealth. So that's how this particular Genesis has given right to intellectual property rights, which are categorized into two, basically. One is copyright and another is industrial property. The copyright basically deals with artistic works. It, say for example, poems, plays, films, musical work, architectural designs, whereas the industrial property includes invention, trademarks, industrial designs, and geographical indications. The different form of intellectual property right are copyright, trademark, patent, industrial design, integrated circuit layout design, and undisclosed information. Copyright is basically an exclusive privilege to the author to reproduce, distribute, perform, display their creative works. And if, say for example, an author or a creator of a song can reproduce, perform, distribute, but in case somebody else want to use that particular song for commercial purpose, he or she has to take permission, take license from the owner. Trademarks, for example, everybody know the tick mark of Nike, that is just do it, is there. So once you see that particular logo symbol, you understand it's a Nike, or for that matter, the Coca-Cola symbol. Right. So trademarks are basically the symbols used to identify either an entity or the goods. These are the representations made in industry for the people by the organization to project their presence as well as their goods. Patents, again, is an exclusive right granted by the government for an invention. That invention that is new, which involves an inventive step and is capable of industrial application. So it is an exclusive right, the right to exclude others from copying, manufacturing, or selling the invention without prior permission from the owner of the invention. Industrial design, again, is a monopolistic right to the proprietor to legally exclude others from reproducing, manufacturing, selling, or dealing in state registered designs. Now, these industrial designs are specific to the 3D or 2D presentation of the goods. That is, it deals only with the shape, and that appeals to the eye. Integrated circuit layout designs, this is a right conferred for the integrated circuits which are silicon based, and there is another intellectual property right which is practiced in industry, that is undisclosed information or trade secret. Likewise, today the KFC formula is a trade secret, or for that matter, even the Coca-Cola formula is a trade secret, which is undisclosed information. And here the onus of maintaining the secrecy and confidentiality lies on the owner of the trade secret. Let's go to the patent, the intellectual property right. To understand, let's see the definition that is defined by the statute, the Patent Act 1970. The Patent Act 1970 defines patent as patent means a patent granted for an invention under this act. Now, this particular definition has three elements in it. This particular definition has three elements in it. You can see the granted. Now, this granted part is dealing with the procedural law, the type of right to be granted. That is defined by the procedures in the law. The second element is for an invention. Now, the substantive law of the patent defines what is an invention and what is a patentable invention. So, and the third element is under this act. This under this act implies that there has to be a procedural aspect verified, tested, and implemented and executed for granting this particular patent right to an invention. So basically, the one sentence definition have coverage of the complete patent act. What is patent? As I said, patent is an exclusive right now granted. Granted by whom? Granted by the government. To whom? To the applicant. To the applicant for his disclosed invention. Now the right is granted to the disclosed invention of industrial product. What type of invention it should be? It can be an industrial product or process which should satisfy a criteria of being a new, non-obvious, useful, and patentable. Now, there are certain subject matters which are defined as patentable, and there are certain subject matters which are defined as non-patentable as per the criteria in the Act. So basically, patent is an exclusive right granted by the government to the applicant for his disclosed invention of industrial product or process which should be new, non-obvious, useful, and patentable as per the patentability criteria laid down by the national law. So patent is basically a legal protection which gives an inventor the right to exclude others. Again, I am specifying patent is a negative right. It gives you authority, or it gives authority to the owner of the patent to exclude others from performing certain activity in the country of issuance. Now, the patent right is basically a territorial right. So, every country has to issue a patent in that particular specific territory or their jurisdiction. So, it is a territorial right. So, it a legal protection that a inventor or the owner of the patent gets is again a territorial protection. Okay, and this particular patent or the exclusive right is for the set of number of years. That is the period specific. It is the right for a specific period, and this right is conferred to the owner of the patent or to the inventor of the patent for in exchange of disclosure to the public. It is expected and it is required that the inventor and the applicant of the patent shall disclose the invention to the public. Okay, let's see what are the important features of patent right. Patent, as I said, is grant of exclusive right by government to the inventor or his assignees for his disclosed invention. Now, this patent right enables the patentee to take legal action as it is a legal right. So it allows a patentee to take legal action against any person who is exploiting the patented invention without consent or license from the patent. The patent is granted again for a limited period. In India, it is for 20 years and can be enforced only in the country where it is granted. As I said, it is a territorial right or it is a jurisdiction specific right. So for India, the patent is granted by Indian government. Likewise, for other countries, the patent is granted by those respective government authorities. The patent right basically enables the inventor to derive material benefits. Now, what are the material benefits? Basically, it is the commercialization, right? You can commercialize your patent by way of either converting it into a product or by way of licensing it or by way of selling it. Now, when the right is conferred to the patentee, there are some limitations to the patent right. First limitation is when a patent right is conferred, it is expected that patent owner is required to work his invention by himself or his licensee for retaining the exclusive right. That means the patent owner shall convert the patent into a product and bring it into a market. The right is, though the exclusive right is conferred, it is conferred in a public interest that the invention that is invented will be used for the benefit of the public. And considering this, a limitation to the patent right is enforced here that the patent owner is required to work his invention. Now, if a patent owner don't work his invention, it is considered as an abuse of patent right. So abuse of patent right by not working or by insufficient working or by unreasonable pricing of the product may entail grant of non-voluntary license to the third party. This is another limitation and act put forward by the government, wherein if a patent owner do not work patent, that means he don't convert it into a product and bring it in market for the use of the public, or he or she do not work the patent with the sufficient potential so that the demand of that particular product is not met, or alternatively, if the patent owner worked the product but sorry, excuse me, at the unreasonable price, it makes it available to the public. In such situation, government holds a right to grant a license to a third party for the production or for the manufacturing of that particular product based on the patent and bring it to the market. The patented invention, another limitation that is put forward by government while laying out the legislature of this patent law is the patent invention may be used by the government or by third party authorized by the government for its own purpose. In case government feels it's necessary for them to use the invention for the welfare of the public, government may intervene and either by themselves use the invention or may appoint a third party to produce the product and make it available to the public in the market. Another limitation to the patent right is the patent law required disclosure of the structure of the invention. Now, when an owner of an invention applies for a patent right, it is expected that the owner of the invention will provide a complete disclosure of the invention and the best mode of the practicing that invention. That means best mode of implementation of that invention. So that the disclosure should be so clear that any person skilled in the art, now person skilled in the art is a person who have some technical know-how of that particular domain. So any person skilled in the art can work the invention and convert it into the product based on the disclosure. So this is one of the most important requirements set put by the law while offering or while providing the patent right to the owner of the invention. Patent applications are typically published after 18 months after filing and thereafter upon grant. So basically, once you file a patent, the document will become a public document after 18 months. And also the once the patent is granted, the granted patent will be published again for the public use. However, for the period of 20 years, the monopolistic or exclusive right lies with the owner, though the document remains in public. An application is free, an applicant is free to disclose the invention any time after the application is filed without jeopardizing patentability. Now, what is this particular limitation? Applicant is free to disclose the invention. Why this is? Because there is a criteria laid down that to have an exclusive patent right, the invention should not be worked prior to the application of the patent. So an applicant is not expected or should never disclose the invention till he files an application for patent. But as soon the applicant files an application for patent, the applicant is free to disclose. For disclosure of his invention after filing a patent does not affect the patentability. So it is again a limitation that on the applicant or owner of the invention not to disclose the invention before applying for a patent. To summarize, what is a patent right? A patent right is not a right to perform an invention, or just direct a monopoly in marketplace, but it is a right for exclusion of others in regard to the working of patentee's invention. That means it is a right that you have to exercise and exclude others to protect your interest in the market. So basically, patent doesn't directly grant a monopoly, but though it is a monopolistic right. Now, why the inventions needs to be patented? Again, the invention needs to be patented because they can act as source of recognition for the inventors. A patent act as a source of recognition for the inventors or the owners. It is an incentive to develop a commercial product. Why it is an incentive? Because first of all, it allows you to convert, or it allows you to establish your product as a unique product in the market. At the same time, it allows you to exclude others from copying or manufacturing same product. So there is a assurance of commercial gains if a patent is converted in appropriate manner to a product that is available to the public. A patent or the invention can be licensed to an existing company, or it can be a spark to start a new company. Based on this patent, you can assure that yes, there is a marketplace which can be commercialized and through an organization. So either you choose to license it to an existing company, or you can start your own organization. And as the basic thing, it is a protection against the imitators. So imitators will not be allowed to copy your invention. So this few things makes it necessary for an invention to be patented. Now the legislative framework for patent administration in present days is laid by the Patent Act 1970 and the Patent Rules 2003. In India, the legislative framework, though it is presently under the Patent Act 1970 and a Patent Rule 2003, if we go back to the history, the first Indian Patent Act was first promulgated or first defined in 1856. This patent law was based on the British patent law, and this patent law went into modification from time to time. However, after the independence, a new patent law was made in the form of Indian Patent Act 1970. The act has been now radically amended to become fully compliant with provisions of TRIPS. TRIPS is a treaty basically for the unification of the patentability criteria across the globe. So the criteria for the patentability and the procedures and aspects are unified through this particular treaty. The most recent amendments were made in 2005, where the procedure and were preceded by the amendment in 2003 and 2002. While the process of bringing out amendments was going on, India also became member of a Paris Convention, a Patent Cooperation Treaty, and Budapest Treaty. Now, India is part of many international treaties. India is basically a member state of World Intellectual Property Organization. World Intellectual Property Organization is an international organization that is responsible for promotion of the protection of intellectual property throughout the world. India is also a member of, say, World Trade Organization with effect from 1st January 1995. It is a member of Convention Establishing World Intellectual Property Organization. It is a member of Paris Convention for Protection of Industrial Property. Now, this Paris Convention is a convention by way of which an applicant or owner of the patent is allowed to file application within 12 months from first filing of the application in country of origin to the countries, to the member countries of the Paris Convention. Again, repeat, Paris Convention is a treaty which facilitates a patent applicant to file patent application in the member countries within 12 months from the first filing of the patent application in the country of origin. There is another treaty called Patent Cooperation Treaty. Now, this Patent Cooperation Treaty has around 140 plus member countries and also provides a international filing procedure wherein the inventor or the owner of the patent or applicant for a patent is provided with or is allowed to file a late application up to 30 months from the date of the priority in any of the members country, okay, from the date of the priority in any of the member country. So this particular treaty provides some comfort to the applicant so that he can decide in which all countries he or she need to file a patent application. A Budapest Treaty with effect from 17 December 2001. So Budapest Treaty is a wherein though it is signed in 1970, the India has enacted on it from 17 December 2001. Now let's see what is invention, because ultimately when we talk about patent right, it is for the invention. So the statute defines the invention as a new product or process involving an inventive step and capable of industrial application. Now, if we look at this definition, it means a new product or process involving an inventive step and capable of industrial application. Now, the statute also further defines what is a new invention means. The new invention means any invention or technology which has not been anticipated by publication. When the definition of invention talks about new product or process, okay, so what is new? So new is that which is not anticipated by publication in any document, or it is not used in any country or elsewhere in the world before the date of filing of the patent application. Now, though I said that patent right is a jurisdiction specific right and it's a specific to the jurisdiction, however, the newness of the invention is established by exploring the prior art across the globe. Okay, so it has to be new over any publication or any document across the globe, published or available across the globe. So let's see what are the patentable inventions. A patentable invention is a new product, as I said, new product or process involving an inventive step and capable of being made or used in industry. It means the invention to be patentable should be technical in nature and should meet the following criteria. What is the criteria? The criteria laid down are: first is novelty. Novelty is the criteria which states that the matter disclosed in the specification or the application is not published in India or elsewhere. So this is again a global scenario. It should not be published anywhere across the globe before the date of filing of the patent application in India. And this is what is the criteria that lays a limitation on the inventor for not to disclose his invention before applying for a patent. Okay, or the invention should not have been disclosed by any publication by any other person. The inventive step. What is the inventive step? The invention is not obvious to the person skilled in the art in the light of the prior publication knowledge or document. That means the inventive step is a step which is appearing as if a not obvious step. A person skilled in the art with general thoughts and referring to general available document may not be able to or should not be able to arrive at the invention. So basically, the prior publications or the knowledge or the document should not provide any teaching so that any person skilled in the art can arrive at the invention for which a patent is applied. Okay, and the industrial applicability. Now, when you're claiming for a patent right, basically the right is conferred in the public interest. So it is expected that your patent or your invention should be brought in use for the public. And for that matter, your invention has to be industrially applicable. That means the invention should possess a utility so that it can be made or used in an industry. And the fourth criteria, which is again laid down by the Indian legislation, is that the invention should not fall under the group of the inventions. Those are defined as non-patentable in the statute or according to the law. Okay, so basically, when we are talking about what are patentable inventions, the inventions which are novel, having inventive step and industrial applicability, and that does not fall under the group of the invention that are not patentable according to the law, are the patentable inventions. Novelty, as I said, novelty and invention will be considered as novel if it does not form a part of a global state of art. When we say the global state of art, it is any disclosure disclosed across the globe. Say, for example, the information appearing in the magazine, technical journals, book, newspapers, all these constitute to the state of the prior art. Even the oral description of the invention in a seminar or conference can spoil novelty. Okay, and the prior use of the invention in the country of the interest before filing of the date can destroy the novelty. So basically, again, novelty is the criteria that imposes a restriction on the inventor not to disclose his invention before filing a patent application, or it awaits an inventor to verify that the invention that he is claiming is not disclosed by any other document. The inventive step. Now, when we say the patent invention should have an inventive step, what is the inventive step? Basically, the inventive step is a feature of an invention that involves technical advancement as compared to the existing knowledge or having economic significance or both. Now, for example, when we say that, yes, there was a landline telephone existing, so telephony was known. But when it comes to the wireless telephony, yes, there is a technical advancement. There is a technical advancement wherein by way of which the person or the user is allowed to use telephony without having a hard connection. To attend this, lot of hardware needs to be developed or protocols needs to be established. So these are the technical advancements. So when we say the inventive step, there has to be a technical advancement. Okay. So inventive step is again feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, making the invention non-obvious to the person skilled in the art. So when landline phones were existing or hardware phones were in existence, it was difficult for any general person having general knowledge of communication to imagine wireless communication, or for that matter to imagine mobile communication. Okay, it is the continuous development or continuous technical advancement that has led to the mobile telephony, right? So when a wireless adapter is developed, again it is a technical advancement. So there lies the inventive state. Now, industrial applicability, capable of industrial application in relation to an invention means that an invention is capable of being made or used in the industry. So basically, when you claim an invention, it should be in the form that it can be converted into a product. It can be converted into a product. Okay. Now we see what is a patentable invention. Okay, let's go to the non-patentable invention. The statute or the law clearly defines what are non-patentable inventions. The product or processes which are not patentable are those which are not inventions as per the Indian Patent Statute or the Indian Patent Law Act, and the inventions related to the atomic energy. Now, the section 3 of the Indian Patent Act defines what are non-patentable inventions. According to the section 3A, an invention which is frivolous or which claims anything obvious contrary to the well-established natural laws. Say, for example, the natural law of energy says that energy cannot be created or destroyed. It can be converted from one form to the other. However, if we look at the example, say, for example, a perpetual motion machinery to be giving output without any input. So this is basically something that is contrary to the established law, okay, established natural law. So such inventions or such things are not patentable inventions. So the section B, 3B of the patent law defines that an invention, the primary and intended use or commercial exploitation of which can cause serious prejudice to human, animal, or plant life or health or to the environment. That means an invention which when practiced in the industry may result into an harmful product to human, animal, plant life or health or to the environment are not patentable. The examples which may be the adulteration of the food, a process or a method for adulteration of the food. This is an invention. It can be an invention. A method may be inventive. However, it is not patentable because it is directly harmful to the human being or to the health or even maybe to the environment. The section 3C states that the mere discovery of scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So this is basically a discovery of scientific principle or formulation that is occurring in nature. That is occurring in nature is not patentable as per the Indian Patent Act. Now when we go to the section 3D, this section 3D states that the mere discovery of a new form of a known substance, which does not result in enhancement of the known efficacy, which does not result in enhancement of the known efficacy of that substance, or mere discovery of any new property or new use of known substance, or of the mere use of a known process, machine, or apparatus unless such known process results in a new product or employs at least one new reactant. Now, section 3D is very important from the industry point of view, because it is laying down a specific requirement for the patentability of the drug products or pharmaceutical products, that the product should not be just a discovery of new form of a known substance which does not result into enhancement of the known efficacy. Now here the statute also provides the explanation stating that for the purpose of this law, the salts, esters, ethers, polymers, metabolic, pure form of particle size, isomers, mixtures of isomers, and so on of known substance shall be considered to be the same substance unless they differ significantly in properties with regard to the efficacy. Now, the Indian statute or the Indian law do not directly define efficacy. However, in in a case of Novartis AG versus Union of India, the Honorable Supreme Court have defined the efficacy or upheld that in the case of medicine, efficacy means the therapeutic efficacy, and physiochemical properties of substance do not meet the requirement of therapeutic efficacy. Now see, when you say the efficacy, there are certain patent applications, or people may tend to apply for a patent by modifying the physiochemical properties of the substance. Okay, or you can say that the physiochemical properties will be enhanced for a known substance, and a patent application may be applied for. In such cases, the law expects that there has to be a therapeutic efficacy and not just the efficacy in terms of physiochemical properties. And even the court held that patent applicants must prove the increase in the therapeutic efficacy, and just increase bioavailability alone may not necessarily lead to an enhancement of the therapeutic efficacy. So basically, and also the court upheld that in any given case, the enhanced efficacy must be specifically claimed and established by the research data. So here, the section 3D is putting an emphasis and forcing the pharma industry or an inventor in the pharma domain or for the chemical drugs to provide the experimental data that defines the therapeutic efficacy of a drug. Okay, so here you may have to provide all the experimental data. Now, when you're applying for the patent, yes, the experimental data available needs to be put in a concise form so that you can precisely define the therapeutic efficacy. This is the onus on the applicant of invention which is in the pharmaceutical domain. Now the section 3E of the patent law states that a substance obtained by mere admixture resulting only in the aggregation of properties of components thereof or a process for producing such substance. Now here, just generating a mixture of two or more components is not patentable. The example may be mixture of sugar and some colorants in water to produce soft drinks, mixture of different types of medicaments to cure multiple diseases in a mere admixture of the substance, a process for producing substance by admixing. The section 3F of the Indian Act states that a mere arrangement or rearrangement or duplication of known device, each functioning independently of one another in a known way. So basically, when you arrange multiple, say, devices or multiple designs or instruments or components in a manner that they don't interfere with each other's working, but they independently work in a similar manner when they will be placed separately. In such cases, such arrangement or rearrangement is not patentable. In India, according to the section 3H, the method of agriculture or horticulture is non-patentable. Further, the section 3I says that any process, again, this is important from pharmacy point of view, any process for medical, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being, or any process for similar treatment of animals to render them free of disease to increase their economic value or that of their product is not patentable. That means the method of treatment is not patentable. For example, the method of treatment for malignant tumor cells, method of removal of dental plaque, these are not patentable. Okay. The section 3J of the Indian Patent Act again says that plant, animals in whole or any part thereof other than the microorganisms, but including seeds, varieties, and species, and essentially biological processes for production or propagation of plants and animals are not patentable. Say, for example, clones and new varieties of the plants are not patentable, but the process method of preparing genetically modified organisms. Now, this is the method of preparing genetically modified organisms are patentable. Section 3K talks about non-patentability of the mathematical or business method or a computer program per se or algorithms. Okay. Section 3L is talking about non-patentability of literary work, dramatic or musical or artistic work. This kind of works are having a protection of copyright and they are not patentable under Patent Act. Section 3M is talking about non-patentability of mere scheme or rule or method of performing a mental act or method of playing a game. A performing mental act can be method of teaching, can be method of learning, it can be a method of counting. So it cannot be patentable as per the Indian Patent Act. The section 3A is again a presentation of information is non-patentable under Indian Patent Act. The section 3O of Indian Patent Act says that topography of integrated circuit is not patentable because there is a separate legislator provision to protect the topography of integrated circuits. Okay, and an invention, the section 3P states that traditional knowledge is not patentable under Indian Patent Act. Further, the Indian statute defines that any invention relating to atomic energy are not patentable. This is a specific provision laid down by Indian patent legislature for non-patenting the atomic energy related invention. Okay. However, there is a method established for patenting of microbiological inventions. The Indian Patent Act now provides specific provision in regard to the patenting of microorganisms and microbiological processes. It is difficult to describe a microorganism on a paper. Hence, a system has been developed to deposit stain of microorganisms in some recognized depositories. Okay, an international treaty called Budapest Treaty was signed in Budapest 1973 and later on as amended in 1980s and was enacted in India in 2001. Okay, this Budapest Treaty is an international convention that governs the recognition of the deposits in the official approved culture collection for the purpose of patent application in any country that is the party to this treaty, and India is a party to this treaty. So basically, now in India, the Institute of Microbiological Technology, Chandigarh, is the first Indian depository set up under the Budapest Treaty for the deposition of the strains in a culture deposition of the strains. Now, when an inventor deposits the strain of microorganism in a recognized depository, this organization assigns a registration number to the deposited microorganism. This registration number needs to be quoted in the patent application dealing with the microorganism. Now, these were the non-patentability or non-patentable inventions. Let us now see the scenario where most of the time in educational institute, it is always a debate whether it should be a publication or a patent. Now, if we compare publication versus patent, in case of scholarly publication, the authorship is somewhat negotiable. In the sense, the authorship can be flexible and multiple authors can be introduced. Whereas in case of patent, the inventorship is a matter of law. That means the inventors should be the one who have worked on the invention and who have worked the invention and invented it. Okay. In case of scholarly publication, you must have done the work. That means you have explored the work. At the same time, when you look at the patent, patent encourages a constructive reduction to the practice. That means you need to convert your ideas, and it encourages that to convert that idea into a product. Now, in case of scholarly publication, effort is paramount. That means here you need to refer to the publications, or you need to refer to the data and aggregate and present your publication. Whereas in case of patent, the concept is paramount. That is, conception is paramount. That means you need to conceive the idea by yourself. It should be inventive and novel. So it needs to be conceived by self. Further, the ideas can interfere with subsequent patentability. Now the scholarly publication, when they are published, the ideas can interfere with the subsequent patentability. But that means if you publish it and then go for the patent for patenting, then there can be an issue in patentability. Whereas in case of patent, if you disclose your idea as a format of patent or as a patent application, future uses may be possible and strengthen the patent. The further use may be possibly strengthen the patent, okay, or strengthen your concepts. Now, in case of scholarly publications, only directly comparable results can be lead to loss in priority. When you directly comparable, when you publish or when you provide directly comparable results in your publication, definitely you are saying that yes, there is a prior art existing. Now, in case of patent, it results from the analogous system and can result into prior art and obviousness rejection. So basically, a patent may result into a prior art which was not known to the inventor at the time of invention, but then brought forward or by the legislator during the examination process, and may lead to a rejection. Okay, so there are advantages and disadvantages of patent, for filing a patent or a publication. However, when you go for the publication, you are damaging the patentability of your invention. Now, who can apply for the patent? Any person, whether a citizen of India or not, can apply for a patent in India. The person who is true and first inventor of the invention, or his assignees, that is the applicant can be company, institution, or the legal representative of the assignee or the first inventor, either alone or in joint or jointly with another person, can apply for the patent. While dealing with patent filing, what are the basic care that one should take is, first is, don't publish before you file a patent. Don't publish your work before you file a patent. If you're thinking of filing a patent and if you're not ready with the complete disclosure or complete invention, you may book a priority by filing a provisional application. Okay. When you are thinking of filing a patent, the company, institution, or the owner of the patent should ensure the security of data, that the data may not be lost to the public in any manner. The owner of the patent should sign agreement, or the inventor may sign agreement with the employee regarding the inventions originating in the company. or the company may sign an agreement with the employees for the invention originating in the company to maintain the ownership. A non-disclosure agreement, whenever an invention is disclosed prior to the filing of the patent, preferably a non-disclosure agreement should be filed. Now, the law do not object use of say patented invention for experimental work. Okay, and most importantly, when you're thinking about filing a patent, inventor or the applicant is advised or uh, requested to conduct novelty or inventive search for invention before applying for the patent, because this will provide you an insight whether your invention that you have conceived is actually a patentable invention or it does exist a prior art across globe anywhere. If we look at the basic technical parts of patent application, the patent application have abstract, which describes the crux of the invention, or which details in brief the invention. The background of the invention gives you the problem statement. The summary of the invention talks about the in brief the inventive step of the invention. The figures with brief descriptions supports the description, the detailed description. The detailed description fully discloses what the invention is, how it is made, and what is the best mode of implementing it. However, claims is the most important part of the patent application, because the protection is to what is claimed. So basically, there are two types of claims which forms the part of the patent: independent claim and dependent claim. Independent claim is expected to disclose all the essential features of the invention which are essential to work an invention. And the dependent claims are further describe the invention or implementation of the invention. Now, the Indian statute provides different types of applications that can be filed in India. The types of applications which can be filed in India is: one, ordinary application; second is convention application; third is PCT international application; fourth, PCT national phase application; fifth, application for patent of addition; sixth, divisional application. What is an ordinary application? Ordinary application is which is filed, or an application for a patent made in the patent office without claiming any priority of the application made in a convention country, or without any reference to other application under process in the office, is called an ordinary application. That means ordinary application is the first application that is originated in India and filed it in India as per the Indian statute. Then we have a convention application. Now this convention application is application which is filed claiming a priority. Now this convention application is filed by claiming a priority on the application which is filed in any of the member country of the Paris Convention. Okay, so basically when an application is filed in a patent office claiming the priority based on a similar application filed by him in one of the convention countries, it is called the convention application. Now, according to the Paris Convention, it provides a period of window of 12 months. So a convention application should be filed within 12 months from the date of the priority, that is the first filing of the application in the convention countries. Application. The PCT international application provides an international filing. Basically, PCT is a patent cooperation treaty that provides an international filing system for patents in which an applicant gains an international filing rate for his application in all designated states. Now, the PCT is a treaty where there are 140 plus countries who are member of the treaty, and by way of filing an application, PCT application, you designate to file a patent application into all these 140 countries, but you get an extra period. That means you are allowed to file up to the extended period of 30 to 31 months, 30 to 31 months to file those applications in those member countries. So this additional time that is enjoyed by the inventor can be utilized to take a strategic decision. Within this 30 months, the inventor can evaluate whether he needs to really file in those countries or not, by working his patent, by evaluating the commercial aspects of the patent. Okay, so this is an international application, the provision provided under the PCT international application process. Then comes the PCT national phase application. Now, when an international application is made according to the Patent Cooperation Treaty designating India, if a PCT application is filed in foreign countries, the inventor of that application or owner of that application can file a national phase application in India within 31 months from the priority filing date. That is the first filing date in the parent country. Okay, so this under this particular treaty, when a foreign applicant enters and files an application, that particular application is termed as a PCT national phase application. Now, when an inventor files an application, the inventor may continue to further do research and enhance his patent. Okay, in such cases, the inventor may feel that I need to file a improved invention. Okay, so when an applicant feels that he has an invention which is a slight modification or one for which he has already applied for a patent in India, the applicant can file a patent of addition. Only the thing is, the patent of addition expires along with the main patent unless it is made independent. Now, there are certain criteria or certain procedures by way of which the patent of addition may be treated as an independent patent if, however, generally the period for which the patent is granted is same as that of the main patent. Okay, another aspect is, as per the Indian statute, one patent application should contain one and only single invention. However, when an applicant for a patent claims more than one invention, the applicant in one application, the applicant on his own request ought to make the official objection raised by, because such objection that there are multiple inventions claimed in this one single application can be raised by the controller. Official objection raised in this regard by the controller may divide the application and file two or more applications as applicable for each of the invention. Now, this divisional applications are all treated as an independent application, but the restriction is the divisional application cannot contain or cannot have a scope broader than the parent application. That means all the disclosures should be present in the parent application disclosure. Okay. Now, after this, let's see how does one can obtain a patent. Okay. So, to obtain a patent, it is the inventor's duty to first go for the assessment whether or not the invention is patentable and marketable. Okay, do the assessment, then go for the provisional filing, go for the international filing, then examination rounds, because after filing the patent application, it will go through the examination and then hearing, and maybe thereafter you can proceed with commercialization. Okay, the total average time to obtain Indian patent is around 3 to 6 years. The basic patent flow, or how the procedure works. It starts with filing of a patent application. Either you can file by filing a complete specification, or you can file a provisional specification, and within 1 year you can file a complete specification. Further to the filing of complete specification, the application will be published within 18 months. However, the applicant is required to file a request for examination. Upon filing the request for examination, the patent office will examine, and it will provide you the examination report, to which the applicant needs to be responding, and if the responses are satisfactory, then it will result into the grant of the patent. The grant of the patent will result into publication of grant patent in Official Journal. Now, this procedure also has some bifurcations. That is, in after publication, there may be somebody may oppose your patent through pre-grant opposition, or even after the grant of the patent, within 12 months, a patent can be opposed by filing a post-grant opposition. Okay. So further to this process, I would like to go through some of the basic questions which arise in mind of people generally. What is cost associated? What is the cost associated with obtaining a patent? Now, in India, the government fees for filing application by a natural person or an individual is 1/4 to that of the fees for other than natural person, that is company and organization. Okay. However, obtaining patent can be expensive, especially if protection is desired in many countries and translation of the patent application is required. The initial cost for obtaining a patent are related to drafting of the specification and filing the application. After that, there may be cost associated with responding to any objection being raised by the patent office, and additional fees patent office may request you to pay, depend on the procedural aspects. Are there any cost after a patent has been granted? This is another query that generally asks or arises. Yes, in India, the India charges renewal fees which must be paid after the patent is granted. The renewal cost generally increases during the term of the patent and varies from country to country. It is a proprietor wish to enforce the patent at their will. If a proprietor decides to enforce the patent, there will be a legal cost associated with suing the infringer, which can be very significant. Yeah. Another next question arises, is it necessary to seek patent protection in all countries at the same time? When a patent application is filed, in one country, equivalent cases directed to the same invention can be filed in other countries within 1 year, claiming the priority date of the initial filing, or you can explore the route of the PCT to file delayed application. Okay. Thus, the applicant has a long period from filing an initial application in their own country and to decide whether to spend money filing applications abroad. When can I enforce my patent? Now, while a patent application is pending, the proprietor rights are very limited. A patent cannot usually be enforced until it has been granted. Yes, the grant of a patent allows its owner to exclude others from exploiting the patented invention. Okay, this exclusive right of the patent owner has two main applications. One is protection against infringement and the possibility of assigning or licensing the right in part or in whole. Okay, so basically the legal tools, those are provided in regard to patent rights. Those are the legal tools to oppose a patent are pre-grant opposition, post-grant opposition, and intellectual property appellate board, where you can appeal for opposition. Okay. Now the patent plays a vital role in transfer of technology. Basically, the transfer of technology gets initiated from the research or development, which results into an invention. The invention can be further evaluated for the protection, and IP protection can be sought, or a patent can be obtained. Further to the obtaining patent, the patent can be put into the market either by licensing or by practicing it to the product. Okay, or and thus it can be put to the public use, and commercial benefits can be obtained by the technology transfer. Now, why one should think of licensing? What is the motivation? That by licensing you can get the royalties. By licensing you can go for the mergers and acquisitions, and by licensing, you may encourage the technological development. You may have reached to a concept, to an invention, or to a patent. But for further development, you may have a partner with you who can, take the burden of further development. So it's basically a patent gives you a motivation to explore any of these options and benefit out of it. Licensing can be of three types. One is exclusive licenses, other is sole licenses, and non-exclusive. Exclusive license, where the patent owner grants all the rights to the licensor, and the licensor don't hold any right and don't retain any right. However, in case of sole licenses, the licensor also holds the right to practice the invention along with the licensee. And in case of non-exclusive licenses, the licensor holds the right to even license it to multiple licenses. Okay. Now, the infringement of a patent occurs when a competitor makes use, sales, offers, or offer to sell, or imports an embodiment of the invention without the permission of the patent owner. What are the remedies for the infringement? How a patent owner can really stop an infringer? So, patent owner can stop an infringer through the injunction proceedings by challenging him into the court or suing him into court and claiming the damages. Now, the damages can be claimed retrospectively from the date of the publication of the patent application after the grant. Okay, so basically, though during the proceedings of the patent procedure, though you cannot have right to really enforce the patent, but once the patent is granted, it can be enforced retrospectively from the date of publication of patent application. So this is one of the advantage of having an early publication date. Now, when you are talking, or when you're thinking of obtaining a patent, you need to work with a patent attorney who have appropriate knowledge of the procedures and all. So when you're working with a patentee, it is requested to inform the attorney of what you know about the state of the art, because patent attorney is the one who will work on the information provided by you. Okay. So basically, you should give clear indication of what are the differences between your invention and the state of the art. What are the parts of the structure can be changed without affecting the way the invention is used, and what changes can be made in the material and methods for making the invention without affecting the structure. Further, what are the key structural features of that product that results the invention. Okay, these are the points on which you have to provide a complete detailing and complete in-depth view to your patent attorney, so that he can work your invention and file a good patent application for you. I think this covers most of the aspects of basics of filing a patent in India. So I conclude my session over here and request any questions if you have.
Thank you, sir. Thank you for your wonderful session about that introduction about intellectual property and patents.
You're welcome.
Excuse me, sir. Ajit, sir.
Yeah.
Sir, now you have been changed as the host. Please change Kannan sir into the host.
Hello. Sir, may. Sir. Hello, sir.
Yeah.
Sir, allow me in the meeting, sir. Kannan C. Participant list, sir. In the participant list.
Dr. Sedhil, you're asking me to allow you?
No, sir.
Yes, sir. No?
Myself, Kannan, sir. Kannan C.
Kannan C is there. Just that allow, sir. That allow Kannan C.
Admit, sir. In the participant list, Kannan C, admit.
Kannan என்னாச்சுங்க?
சார் எனக்கு இன்டர்நெட் கனெக்டிவிட்டினால நான் டிஸ்கனெக்ட் ஆயிடுச்சு சார். அதனால என்னோட ஹோஸ்ட் பெர்மிஷன் அவருக்கு ட்ரான்ஸ்ஃபர் ஆயிடுச்சு சார்.
ஓகே ஓகே.
இப்போ ஹோஸ்ட் அவரு தான் சார். சாரு.
இதுதான் பண்ணோம். இவர் வந்து இப்போ நான் அதனால இவர் வந்து என்கிட்ட இப்போ சரி முதல்ல கிரியேட் இல்லையா, அதெல்லாம் நம்மளா இது நோண்டி கேட்கணும். அதாவது சொன்னா நான் சொல்லுவேன் அப்படியா அப்படின்னு சொல்லுவேன். நம்மகிட்டயே கேட்கலான்னா நம்ம எதுக்கு நம்ம நோண்டி நோண்டி கேட்கணும். இல்லை இதுதான் பணம் தான் இஷ்யூ அப்படின் போது நான் தரேன். யார் யாருக்கு கடன் 10 இடத்த கொடுக்கணுமா, 50,000 1 லட்சம் வாங்கிருப்பியா, 10 இடத்த கொடுத்தோன்னா 10 பேரோட இன்சு முடிஞ்சதில்ல. ஹலோ
ஹலோ சார்.
Yes. Hello.
Hello.
Yeah.
Sir, just in the participation list, just the Kannan C, your name is there, sir. Just you can make it allow, sir.
Sir.
Hello, Ajit, sir.
Yeah. Let me check.
Sir, in the down, participants will be there, sir. Just to click the participants, sir.
Yeah.
So in the side, a lot of participants' name will be there displayed, sir. Myself.
I'm searching for Mr. Kannan.
Yeah, the Kannan name will be there, sir. This list, just make it allow it.
I'll search.
Yeah.
Can you spell Kannan?
K-A-N-N-A-N, sir.
But I'm not able to see him. Even if I search for K.
Just a minute, sir. One more time, I will ask permission, sir.
Yeah.
Now I'm asking permission, sir.
Now it will display, I think so, sir. It just allow, sir.
No, Kannan, I can't see here.
Sir, now I asked freshly, sir. Now it will show, sir. Now only I asked permission.
Actually, Kannan வரல. உங்க நேம் அதுல வந்து லிஸ்ட்ல.
Kannan C, yeah.
Yeah.
Okay.
Okay.
And there is one more request, Kirti Vasan. Should I admit?
No. No, Kannan C only is used, sir.
Yeah.
No, sir. Allow பண்ணிட்டார் sir. Sir, Ajit sir, kindly right click the 3 dot and make me a host, sir.
The 3 dot is there.
To whom? Dr. Chinte?
No. Kannan C only, sir. Myself.
Okay.
Okay, sir.
Yeah. Okay.
Sir.
Hello.
Sir, continue, sir.
Sir, முடிச்சிட்டாரு. Sir, it was over. Completed, no, sir?
Yes, sir.
Yeah. Sir, thank you, sir. Thank you for your wonderful session regarding that intellectual property and about patent, how to apply patent, what are all the criteria and everything have been explained in a very nice manner. So I think so everything students and as well as all faculty members, they might have enriched it. So what is patent and what is intellectual property about it? Thank you, sir. Thank you for your very much for your wonderful session.
Thank you for giving me this opportunity to interact with you all. I enjoyed the interaction.
Okay, sir. Now we will go for the vote of thanks, sir.
Yep.
Tafik, sir. Tafik, sir. Hello. Tafik, sir. Sir, Tafik, sir. Hello.
Sir, Tafik, sir.
Sir, you can give now vote of thanks, sir. Tafik, sir.